Thank you very much, Gemma. So let's get moving. We've got quite a lot of slides to get through today, more because they actually contain quite a lot of information, so that hopefully you can take them away and they can help you later on. Hopefully you don't need to take too many notes. So this is really what we're going to be looking at today. So we're trying to avoid disputes, always best if we can, but if we can't, looking at how to resolve them. So we're not actually going to look too much into dispute resolution, except in terms of thinking about what dispute resolution you might go to if any negotiations fail. So we will be looking at negotiations and therefore, dispute resolution in that context. Note that where I'm talking about contractors, I'm also referring to subcontractors in a subcontract situation as well. Now, the next two slides, well, probably, really depressing. We'll look at these and wonder why we ever do any construction work at all. But they're probably all fairly common to you. So this is basically, 25 years of my life. What I've found causes challenges on construction projects, shall we say. So lots of issues. Sometimes it's a mixture. So basically a lack of preparation, which often manifests itself in starting on site too early, which then means that nobody's actually really ready to start. It sometimes means we have lots of changes, variations, which causes issues, or contractors not really ready, so doesn't really hit the ground running, etc. Which is into letters of intent, because very often you find that letters of intent because somebody wants to see some tangible progress on site, but the reality is that quite often when letters of intent are issued, the parties aren't actually ready to get going on site, and that causes problems. Buying work or experience, my advice to contractors and subcontractors is don't do that unless you have a clear idea as to how you're pricing it, you're going to do the work. I've seen lots of disputes where that has caused in terms of not being sufficiently experienced to do the work, which is never great, and also where work has been bought and then 2 years later, as the project's finishing, everybody's looking at it and thinking, why haven't we made any money on this? And they've forgotten that it was, it was, effectively buying the work. For clients, employers out there, lowest price isn't always the best, and sometimes I think it is very apparent that clients, developers go for the lowest price. Sometimes they don't really understand what they're buying or what they're getting into, which then leads on to the next one, which are nasty surprises. Ground conditions are always an issue, statutory approvals, etc. Then some commercial things like cash flow problems, contractor errors causing subcontractor claims. So there's a whole ambit of items. Just wait till the next slide comes up. And I think the last one that I really want to talk about is lack of collaboration, which can cause a whole load of problems. Very often defects which occur on a project are down to, a lack of collaboration in that, it's a mixture of architects makes, a minor error, or doesn't communicate something, one of the other consultants misinterprets something, and then the contractor does something. So quite often it's a lack of what I call lack of collaboration, a lack of communication between consultants on the one hand, contractor, and the specialist subcontractor. So, you know, there's some of the reasons. I'm sure, you know, we've all got some. Sometimes, unfortunately, you know, we just get into contracts with clients who really don't want to pay, or want to pay as little as they can, or they get into difficulties or overspending later on down the line, so want to try and tighten the belt. So what we're trying to do today is to think about things that we can do to avoid those issues. The first area that we're going to look at, you can get the slide on the screen. Yeah, measures to protect yourself. So what I've said there is the pre-contract review. You know, and what I would recommend is a pro forma. I'm not one for forms and documents. We have far too many of them in construction, but there we are. They're all required. But I think a contract review pro forma is a really useful thing to have. And I think it works all the way through the project, not just whilst you're reviewing and negotiating your contract. So you have a pro forma, and I've got some clients who have the, you can include all the key issues that are relevant to you. I listed, there's a whole raft here. And, you know, hopefully as we go through the seminar this morning, you'll see, you know, why I think all this information is useful. Correct parties, the emphasis on the correct ones, the form of contract you're on, design responsibilities, some of the kind of key contractual clauses, design responsibility, standard of care for both design and workmanship. Some of the commercial terms, so the payment dates, always useful to have that, whether you're the paying party or the party wanting to be paid. You know, if you've got that set out in a nice chart, really clear to everyone who looks at it. I always remember going to a seminar and one of the top construction judges saying that he'd spent, you know, about 3 days or something ridiculous trying to work out what the JCT payment provisions are. Well, if you've got it in a nice flow chart with all the dates, etc., you know, then that's really easy for you and everyone in your organisation to use. Any limitation of liability, really important. Insurance requirements, other commercial issues, so liquidated damages, retention. Also, you know, some of the key procedural issues, so conditions precedent, are there any? You know, these are basically, you know, I just
Hello, Sarah. Can you hear me? Right. Apologies, everyone. We seem to have lost Sarah. The sound seems to have given up. I'm glad you can all hear me. However, I do not quite have the technical expertise for this webinar. So if you could just bear with me for 1 minute and I will try and get hold of Sarah and see if she can get back on. Apologies for this, everyone. I think this is probably our first major technical hitch that we've got going on. Please bear with me for 1 second and I'll just try and get in touch and let Sarah know that her sound seems to have gone. Okay, apologies everyone, just bear with me for 1 moment. Everyone, just to let you know, I've not completely disappeared. I've just spoken to Sarah. Yeah, her computer's just had a bit of a nightmare. She is trying to come in just on another piece of kit, so hopefully she'll be back on in a minute. Yeah, and I know we've had slight issues with a couple of sound connections before, so I think I maybe need to go and sit outside our house with some kind of 4G tower or 5G tower or something and make sure she can get on. But apologies for the delay, everyone. If anyone needs to go and make a fresh coffee, please feel free to just for a moment, and hopefully Sarah will be back on in a second. To anyone who missed that, just, I think she's trying to come back in now through the app. Apologies for the delay. I should really have some kind of music teed up for this kind of issue. But I can see Sarah trying to come back in now as a presenter. These are all the technological issues we didn't know we had until the COVID-19 pandemic. Sarah, if you can hear me, we can now see that you're logged on. We just need the sound, I think. Bear with me one moment, guys. I'll just try and get back into.
Right, so that should, so can you? Can you hear me now?
Sarah, yes.
Now. Right, really sorry, folks. Where were we? Okay, and the last, so we're on the pro forma of all your key provisions. The last kind of section are those extra documents. So bonds, collateral warranties, parent company guarantees, but also things like, is there a programme attached to the contract? And also, one might sound stupid, but what's the specification that's attached to the contract? You know, what's the works information or contractors, employers' requirements, contractors' proposals, because it does happen where people enter into a contract and it's not clear what scope of work is. So looking at to protect yourself, just some real basics here. First of all, is the contract agreed and executed? The executed obviously often sometimes gets missed out. Particularly if you're on a letter of intent, just make sure that you keep an eye on it. It's really, really easy to get into the work and forget about finalising the contract. And ensure that the relevant people are familiar with the relevant provisions. So this goes back to your pro forma. Very often what you find is that in an organisation with contractors, subcontractors, one section of the business is responsible for quoting for the work, negotiating the contract, etc. Then the contracts weren't signed, executed, and it goes to another team. And that's where I think this pro forma can be reused into something else to help those people who've not been involved in the negotiation of the contract, but it helps give them a really clear picture as to what their responsibilities are, which then follow, this next slide follows on from that. In terms of diarising key dates, well, if you've got your payment dates set it out in your pro forma, that's easy for your site staff to do. Know where your conditions precedent are, ditto if it's in your pro forma. Also the procedures for variations, extensions of time, etc. What do you need to submit? Because if you know that, It means that when an event occurs and you need to make a submission, you know what you need to submit, and you're not going to be faced with a situation where you're on the back foot all the time. Also, make sure that when there is any handover, that the technical risks are known to everyone and passed on. And as I say, you know, use that contract pro forma and recycle it so that it can be used throughout the project. Now, I was going to talk a little bit about letters of intent, but actually in August, we're going to do a full seminar on letters of intent. So all I'm going to say on letters of intent is obviously be careful about them. There are two types. Be really, really careful of type, the old-fashioned type that we used to see a lot of, 10, 15 years ago, where it was just literally 2 or 3 lines where clients say, you know, we're going to enter into a contract with you at some stage in the future, but in the meantime, can you get on with, site investigation work or whatever it is. Be really careful, because technically that probably isn't a legally binding arrangement between the two parties. It's basically just the developer asking the contractor for a favour if matters don't proceed beyond that work. What we tend to see more now is this proper legally binding letter of intent, which is usually 2, 3, 4 pages and contains all the terms that you need. And what you're thinking about here is, what if I don't sign a proper contract at some point in the future? This letter needs to contain all the terms that I need. And critically for contractors and subcontractors, we're talking about getting paid and getting extra money if any extras occur, or client doesn't give information that's needed, etc. So just bear that in mind. If letters of intent are of interest to you, come along to the August webinar. So in terms of your contract, what can you do to protect yourself? Well, there are lots of things that you can do. The key one that I've put in here is just about conditions precedent, which we've already touched upon. It's the really, really popular provisions in construction contracts now. 10, 15 years ago, the courts weren't interested in enforcing them. They are now. And really, they probably started with the NEC form of contract, where we see our favourite condition precedent, which is the requirement in the contract that you've got to notify a compensation event within 8 weeks. If you don't, then strictly speaking, you're not going to get any money or any time. So that's why they're so important. And obviously it's why they're so popular with developers and obviously, of course, contractors in their subcontracts. For employers, or for paying parties, so again, it includes contractors in subcontracts, just be careful about your payment notices and your pay less notices, because as we know, if you don't submit them, then the chances are you may be subject to a smash and grab adjudication, which is, it's not phrased as a condition precedent, but it works in a similar way. So you don't get your notice in, and the adjudicator will most likely say that you've got to pay the sum that's been applied for by the party. The party wanting to be paid. So it sort of works like a condition precedent in that it's a failure to submit a notice means that you've got to pay big chunks of money that you wouldn't ordinarily have wanted to do. Just bear in mind with contract clauses generally, even if it's not a condition precedent, or it doesn't say if you don't comply with this, you don't get paid. If you don't comply with your contract clauses, then you are still in breach of contract. And still liable to pay any losses flowing from that breach. So just be careful of that. Don't be lulled into a false sense of security that it's only conditions precedent that have an impact. So for contractors and subcontractors, some measures to protect yourself. Well, obviously one is limiting your liability. To do this, you need to have a very clearly worded clause in your contract. So just be careful, because it's extremely unlikely that such a clause will come in a contract when you're being invited to tender for work. It's usually a clause you are going to have to negotiate into the contract, and therefore you need to make sure it gets into that contract. For example, if you negotiate it and it doesn't actually, the actual words don't get into the contract, then it's probably not going to be any good to you. So just some of the ways you can limit your liability. Well, you can limit the time you're liable. So typically in a construction contract, you are liable for any defects after practical completion for either 6 or 12 years, depending on whether you've signed the contract as a simple contract, 6 years, or as a deed, 12 years. So there's nothing to stop you putting in a clause that says, notwithstanding that this contract's executed as a deed, i.e. 12-year liability, the contractor's liability ends 2 years after practical completion, for example. You can limit your liability in monetary terms. So a common provision that you see is that the contractor will have no greater liability than the contract sum. That's just an arbitrary figure. It just seems to be the commercial norm. You could have a completely different figure. And also one that is fairly common is limiting liability for consequential losses. Be careful with this one, because consequential loss doesn't have a specific meaning at law. You need to make sure you define what loss it covers, and typically it should include loss of profit and loss of opportunity to have any real benefit. Just want to talk about your agreements, both pre and post contract, because what I find is that parties often get in a bit of a muddle in both respects. So what we're talking about? Well, we're talking about when you're entering into a contract, not the situation where you've got lawyers involved negotiating the contract, but where you are sort of negotiating it between yourselves. Clauses are going to and fro. Sometimes there's discussion about going on site and starting work. Sometimes that happens, and then there's a little bit of a muddle because there's no signed contract. Terms and conditions were still being negotiated between the parties. And it then becomes slightly unclear, sometimes very unclear, as to what the contract terms are. So first of all, be careful about your offer and acceptance. Make sure that you're clear that when you are negotiating, none of that is an acceptance. What can turn it into an acceptance is if a party then goes on to site and starts working. That can mean that it's an acceptance of the terms and conditions that exist at that point. It can get into a bit of a muddle if, for example, you're negotiating your terms and conditions, you start on site and then those negotiations continue, because that probably means you haven't got an agreed contract. So just be aware of that, particularly if you're negotiating, you start on site and actually you've gone on site thinking that the terms and conditions have been agreed, and then the other party start to try to continue negotiation. If you engage in that negotiation, then more than likely you will be deemed to be effectively agreeing that the terms and conditions hadn't been agreed when you went to site. The obvious one, try to keep everything in writing. I know it's really difficult, but you know, even if you're having a telephone call, the ideal is you drop an email confirming what's been discussed. Or you know, you've got no real evidence except your own memory, and that's never great if there's a dispute. Make sure what you say, what you cover in contracts is clear. Ditto emails, and that it's correct. Clarify any areas of uncertainty. The same with instructions and variations. You know, anything that's said, it needs to be confirmed in writing. And of course, contracts often require any amendments to be in writing, or they're not valid. So looking at recording agreements. So in terms of priority, I mean, a contract, obviously, you know, that's the top, that's the best we can get. And usually contracts will say that anything that's not part of the contract isn't the contract. So that means it's very, very difficult to say later on down the line, if there's a dispute, well, the contract says this, or the contract says has this document in it, but when we were negotiating, we discussed a different scenario, and it was agreed in the correspondence, but that correspondence hasn't been incorporated into the contract. So make sure that the contract is all inclusive, it covers everything. Aside from that, I do appreciate that on a day-to-day basis, you may be reaching agreements on items that aren't going to be included in a formal agreement. So in that respect, you know, the best kind of document there to prove your agreement, to establish it, will be a letter, an email, a text even, something that has been communicated to the other party. Why does it need to be communicated? Well, primarily because obviously a contract signed between both parties indicating they both agree. If you've sent a letter or an email, you've given the other party the opportunity to come back and say, actually, no, that's not what we agreed. And if they don't, or if they do agree with you, then everything should be okay. Programs, drawings and plans can often form agreements. If a program is sent to a party and they're told, you know, please comply with this program, and they do, then effectively there's been a request to comply with the program, and if you comply with it, then you're basically agreeing to it. Photographs, this is more in the way of evidence, to evidence a claim. Minutes of meeting, we're going to come to them later. Just a note about internal notes, so diary entries, internal emails, etc. Be careful, because you know they're specifically at the bottom of this list because they're not correspondence, they're not in that correspondence section. And what did we think was important about that? Well, it's important because in correspondence it goes to the other party, they have the opportunity to query or dispute it. With internal notes, they don't have that same opportunity, so it has less of an evidential value. We've sort of looked at acceptance by conduct, which is the actually taking an action, so going on to site and starting work, or complying with a drawing or a programme, etc. And yeah, particularly where the other party knows and sees that party actually complying and carrying out that work. So going to site, everybody knows a party's started work on site. That is a really good way of kind of finalising a contract on the basis that there's acceptance by conduct. Okay, so this kind of follows on. I'm just going to quickly skim through this. This follows on from what we've just been talking about. So it sort of merges from agreements into evidence. Evidence basically anything that supports your case. So, you know, we would hope that it's something in writing, because if it isn't, or something in a tangible form, because if it isn't, we're relying on witness evidence, which quite often isn't very reliable, because at the end of the day, not many of us can remember what we were doing, for example, 6 months ago, 12 months ago. So you need your records to support your claims, not only to support liability, i.e., you know, typically you'd be looking at your contract to show this isn't part of our scope, we were asked to do it, and therefore we're entitled to more money and more time. But your project documents support your entitlement to assist in showing your entitlement with regard to the financial implication and also the time scales. And again, you know, another shout out for pro formas, for variations, etc. I think, you know, it just makes things easy. Yeah, with your documentation. So this is all the documentation. You know, I suppose bear in mind, you are producing it on behalf of your employer. So, you know, bear in mind your professional obligations. You know, keep calm, keep cool, and keep professional. Because you just never know who's going to be looking at that paperwork at some point in the future to either support or otherwise a claim that one of the parties is making. Just a note about minutes of meeting. If you have meetings, it might sound really, really obvious this, but if you have meetings, do prepare minutes of meeting, or make sure someone does. Make sure they're circulated, and if you're not preparing them, make sure you check them. It can cause real problems. I know it's a real tedious thing to do, to have to just read through pages and pages of minutes, but it can cause real issues based on the fact that we've already seen that if you have a document that is sent to the other party and they don't query it, then they can be deemed to have accepted it. So if you don't check your minutes of meeting, if you don't highlight errors, then you may be deemed to have accepted things, and that may mean that you're deemed to have accepted some entitlement or other on behalf of the other party. So if you have a dispute that's arisen or a dispute that is arising, one of the things that I think you do need to do is to think about where it might go. And this isn't, as I said earlier, I'm not going to talk about, you know, the merits, the advantages and disadvantages of each, but I don't think you can devise a negotiation and settlement strategy unless you have a clear idea as to where it might go if that doesn't succeed, because it just means that your negotiations become a little bit half-hearted and without any direction. So we have adjudication. We can have a merits adjudication where you just go into the detail, prove your case, provide all the substantiation, all the stuff we've been talking about. Or, sorry, that's a typo, should be merits or smash and grab. And we've touched on smash and grab as well. And hopefully you can see very quickly that which one you choose to, which one you think you might go down, you know, will, you know, have a real impact on how you negotiate in advance. Because, for example, with a smash and grab, you might not negotiate at all. But equally, you know, if you don't check, if you don't look into this, you might miss an opportunity. So you might try to negotiate looking at the merits, where in reality you might be wanting to negotiate and saying to your opponent, well, you know, we can bring a smash and grab adjudication here, which might help your negotiations along a bit. Court proceedings, typically that would be with defects claims rather than with account claims. You might want to think about mediation, particularly if your contract says that the parties should consider it. A contract wouldn't force parties to mediate, because mediate's all about settling, but just using an independent third party to assist in that settlement. So of course you can't be forced to settle something, but you know, that's quite a nice tactical one. If you want to mediate and a contract clause says you should, then you can put pressure on your opponent to mediate, and they're more inclined to agree. There's a pre-action protocol process, which is the precursor to court proceedings. Now, you can use this for any claim. So even if you're intending to adjudicate, you could use the pre-action protocol as a way to try and negotiate. Very simply, the process is you send a letter of claim, and we'll look at that a little bit later on. Your opponent has 28 days to respond, and after that, you're obliged to consider whether you can meet to discuss and try and negotiate. So that's often the end goal, you know, getting some face-to-face meeting and some negotiations, particularly if your opponent hasn't been willing to engage in any negotiations up to then, and you know, if you're reluctant to adjudicate, or if you think that your opponent hasn't really understood your case, or you hasn't explained their case fully, sometimes the protocol is a good way to get information from the other party, or be able to give information in a way that is fairly formal, and therefore, you know, they may be more inclined to look at it and take it seriously. The last point is, don't forget that if you have an admission of liability, you know, that is an admission, so you don't need to be thinking about liability. You just need to be thinking about the quantum and the monetary side of things. If, for example, a claim has been fully admitted, but on liability and quantum, then, you know, you might just want to push the dispute on the basis that there is an agreement and the other party just hasn't stuck to it. I'm going to skim through these because I think we've pretty much touched on adjudication to the extent that we need to, and the smash and grab. I mean, I mean, there's been a lot of it in the press in the last 18 months or so to say that smash and grab is dead and buried. Well, it's not. You know, it's still there. It's probably slightly limited, but you know, not too much. It's still only available in certain situations, but you know, it is worth pursuing. So, moving on to negotiation, and I do think, as I've already said, that it's important to think about where you're going to go, adjudication, court proceedings, etc., when you start negotiating, when you're devising your strategy. So negotiation and your strategy, you know, are really two separate things, I think. Your strategy is usually going to be very broadly, well, we'll negotiate this, and if we don't get a resolution, the next step is whatever it is. And you probably have a slightly more detailed strategy than that. But in terms of your negotiation, what do you need to do? Well, you need to work out what your dispute is. And obviously you need to do that to work out your strategy, particularly if you're going to go down the smash and grab route, for example. The other thing to think about in terms of strategy is, are there any easy wins? So, you may have a number of compensation events, variations that haven't been paid, but there might be one obvious one to pursue. And the advantage of adjudication is that you can cherry pick and just pursue the one which might be quicker, easier, cheaper. Get a good win on that one, and then that might persuade the other side to come to the table and discuss the others. If you are a developer, an employer, and there's a possibility a smash and grab adjudication might be commenced against you, particularly if it's a big figure, you might want to consider a tactical preemptive adjudication for merits, because obviously once an adjudicator has determined a matter on the merits, there's absolutely no point in doing a smash and grab. Think about, do you want to negotiate? Is it always a good idea? My view is that it's never a waste of time to give it a shot. What I would say is, though, don't waste loads of time. If the other party isn't willing to negotiate or is delaying unreasonably, which effectively means they're not willing to negotiate, move on, move to the next part of your strategy. Would you negotiate with smash and grab? It depends on the circumstances. Sometimes parties just like to get the adjudication started to give the other party little opportunity to think about it. But it may be useful, because at the end of the day, following a smash and grab, particularly for a large sum, it's unlikely to be the end of things. So you're most likely to find that there's a follow-on merits adjudication. So in some respects, it is often worth negotiating before you start your smash and grab, because it might mean that you just get both parties agreeing to cut to the chase and agree a sensible deal on the project, rather than having two adjudications, smash and grab and then merits. Review your strategy regularly. In particular, review your timescales. Don't get sucked into ever ongoing negotiations that never come to an end or never go anywhere. Consider sharing timescales. I think that is a good thing to do, because if you've got the checkbook, your interest is going to be in delaying having any negotiations for as long as you possibly can. So if somebody is approaching you and saying, we'd like to discuss this with you, we'd like to reach a resolution amicably, if we can do so within the next X days, that would be great. If we can't, then we're going to have to take this to some form of dispute resolution, or we're going to have to move forward with this outside of any negotiations. And then you're setting clear boundaries and parameters. And as we've seen already, if you get a settlement, even if it's just on part of a claim, particularly if it's just on part of a claim, make sure it's recorded in writing and shared with the other party. So what might your strategy cover? Well, when you're getting into a dispute, you might want to set out your claim fully. I think that has a number of benefits. Sometimes both parties really don't think about a claim in any detail. And sometimes I get claims and parties have simply sent a claim form, as in, compensation event notice, and that's it. That's the extent to which they've considered it. So consider it, I think, as an exercise it is always quite good to set it out formally in writing, because there's a certain discipline there. You know, you need to then think about, well, which contract clauses am I relying on? Which bit of the scope does this relate to? What, you know, why do I say extra money is to be paid, etc. And hopefully it makes you focus on the strengths of the claim, but also the weaknesses, and ditto the strengths of your opponent's arguments and their weaknesses as well, which is always a good discipline to get into. Also, doing this forces you to look at your project documentation, see how it supports your claim, because that can have an impact. If that's really poor, then your strategy might not look as if you know, you're too keen to go to adjudication, because if you've got no backup documentation, it's going to be quite difficult. If you have got the backup documentation, why not show it off? You know, if you're going to send a detailed claim in, show the project documentation, show you know, that good evidence that you've managed to collate through the project. Also, really important, think about who you're going to negotiate with. I always think it's best when it comes to a certain stage in negotiations to try and escalate things to a higher level, probably in both organisations. Take it away from, you know, that very personal level where people have their own individual interests, and take it up to a level where you know, the directors, for example, might have a slightly different agenda. They might want to just get it resolved quickly. They might want things to stay amicable, etc. Tactics, you know, think about what will cause your opponent the most difficulty. So, for example, court proceedings. If you contract proceedings as opposed to arbitration, open to the public, that might not be something that your opponent would be keen. So, you know, if that was the case, you know, you might want to talking about court proceedings, because that might certainly get them to think about negotiating. Obviously, think about future work, future relationships. If you can, if you're a contractor, get information, supporting documents, evidence from your subcontractors. And also bear in mind that some firms, some businesses are more litigious than others. So some, you know, tend to be more up for a fight than others. And sometimes you know, you might want to take that into account in your negotiations, particularly if you do get into negotiations and there are offers, counter offers, and you get quite close. So, content of a letter of claim, and this probably ties in, it probably mirrors pretty much what your action protocol would cover. So the purpose of the letter, you know, if you set that out clearly at the start, it's a really, really good start to the letter. Keep it very high level. You know, basically, you know, you're writing to explain, to set out the details of the claim so that they understand it. You're hoping that they will do the same in response. You're also aiming to try to resolve things by negotiation, but if that can't happen, you know, within a set time scale, then you know, in all likelihood, you'll be, you know, taking the matter to adjudication, or you might want to keep it more vague than that. Then move on to the nature of the claim. So it's a claim for unpaid variations or extension of time, loss and expense, whatever. Set out the details, put the financial impact in, and then bear in mind, of course, that people who will read this might not be particularly familiar with the project, particularly if things are being escalated to director level. Then go through the history of the claim. You know, that's your opportunity to refer to you know, the evidence that you've got, your project documents, etc. And obviously refer to any contract provisions that you rely on. If and hoping that you've complied with any notification requirements in the contract, you know, again, make that point, show off, explain that you have complied, and you know, explain how your quantum, how your delay is calculated. Again, if you've got the documentation, hopefully you have, exhibit it, show it in the letter. And then you're at the stage of, that's my claim, so right, what do we do to move on? So, you know, it might be giving alternatives, as I say, give deadlines. So the alternatives may be you either pay in full or we can meet within the next 10 days. You know, let me have a date that suits you within the next 10 days. You might want to check the dispute resolution clauses in your contract, particularly to see if there's a mediation clause, or sometimes contracts require or suggest that the parties do escalate the dispute if there is one, which is, you know, quite a nice way to get that negotiation going. And also tactically, it's quite nice because it shows the other party that you're looking at your contract, you understand what it says, and you're planning ahead. You know, you have a strategy. It's not just well, can we negotiate? But you know, there's nothing there. You know, there's no indication that there's any strategy after that. And as I've said, consider badging it a pre-action letter. So for your settlement meetings, prepare. I mean, that is the key thing. I think so often people go into settlement meetings and they haven't properly prepared, quite often because they're thinking, well, we'll just have another one in a couple of weeks. You know, I think it's really important to prepare, review your strategy, which is why it's quite good to have it in writing, review your letter of claim. If you haven't sent one, make sure that you've ticked off all those items that we've been through and that you can cover all those items in the meeting. And also critically, consider your opponent's arguments and be ready at the meeting and positively go into the meeting with the aim of addressing their arguments rather than just dismissing them. And, you know, as some people do in so-called negotiations, basically say, well, you know, I'm not even going to consider your arguments, I'm not even going to discuss them or whatever. Consider sending an agenda for the meeting in advance. It sets the tone. It shows that, you know, you're taking it seriously, you're preparing for it, etc. And hopefully we'll avoid the situation where you've prepared and your opponent hasn't at all. Consider the logistics. Are you willing to go to your opponent's office, or is that not possible, etc. At the meeting, take notes and issue some minutes or some notes afterwards. And of course, stay calm. And I think really important, ask questions. You know, sometimes negotiations form a, you know, well, this is my case, I'm going to shout about it or talk about it as much as I can. And then I'm going to switch off whilst you're doing the same with your case. And I think sometimes it's a good mechanism to ask questions to get your opponent to think about, you know, what their position is on issues. So, in summary, be commercial, as always. Follow the contract that's been negotiated. Be careful where you're getting into negotiations, whatever stage of the project. If you reach a resolution to all or part of it, put that in writing, even if it is only interim issues partway through the project. Record keeping it's really boring, but it is so important. It's absolutely critical in construction matters. And I think it's one of the things why we in construction have a dedicated court. We have the Technology and Construction Court, because our disputes do tend to be very, very document heavy compared to other disputes. So be really, really careful about that. As I say, it is tedious, but you can make it simple for your people by having pro formas, making things easy so that they just have to fill things in rather than creating them from scratch. Be organised. All this applies cradle to grave, but particularly with your negotiations. And that's everything for today. Really sorry I cut out. I'm sorry that I've gone over a little bit, but I don't think I've done too bad in view of the little glitch. I'm trying to see if we've got any questions.
Hello. I don't think we've had any questions in as of yet, but if anyone does have any,
so I think Gemma's going to.
Yeah, if anyone does have any questions, feel free to add them in just now whilst we've got Sarah on the line. If not, then I think we'll probably be free to go. I'll just give people a minute if they want to type anything in. But if not, while we're doing that, I'll just remind for people who joined a little bit late, if you would like a copy of the slides, I've had a couple of emails so far. If you would like a copy of the slides, please drop me an email through. Sorry, we've just had one question that I will bring up for you here, Sarah, from Mark.
Yeah, haven't seen it. Well, I haven't. Nothing's gone to adjudication. It's way too early for that. I am seeing claims, a mixture of things with COVID, where extensions of time are being granted, some where they're being refused. I think what people are maybe forgetting about is that just because we have COVID doesn't mean that's an automatic right to an extension of time and more money. With JCT, it's just time typically. It sort of depends, but generally with NEC, you should get time and money, but you have got to show that the virus has caused delay. So with some projects, I think that's not necessarily a given. With a lot, it is. If contractors have genuinely, had to stop work or suspend because of the virus, that's fine. I think some are being rejected on a suspicion that it's not, that the suspension or the delay wasn't actually down to COVID. It was down to quite often an existing delay. So that's what we're seeing. What we have seen as well, just this is court proceedings, and it's more to do with service of documents where a party didn't respond to proceedings that had been issued because they hadn't received them, because everything went to their office and they weren't in the office, so judgment was entered against them. Now, what the court has done on that is that it's set the judgment aside, so it's allowing them to defend. Now, if you were here for the seminar that I did on COVID, I did say when you're issuing notices and claims, do the right thing and serve it in accordance with the contract. But also, particularly with JCT, where services by post, my advice is the whole point of a notice is to tell somebody about something. So email people as well, email the people that you are liaising with. Otherwise, it might just look as if you're trying to serve a notice, but without the other party seeing it, which adjudicators, courts, judges, they don't like that, as you'll maybe understand. We've got another one about disputes arising out of the adverse weather in February. I haven't actually. That's a really good point. What I would say, which you won't want to hear, I suspect, if you're a contractor or subcontractor, is that typically the NEC compensation event, it says that you can make a claim for weather, but the criteria makes it really, really difficult. It's got to be really, really bad weather. So I'm sure we've had worse weather than we had in February. So I'm not sure. Of course, what it depends on, because I think this would be the flooding. Of course, it depends on the locality and where the project was. So I haven't seen any, but the criteria is fairly strict. If you're on JCT, there's probably a little bit more wriggle room, but with NEC, it's fairly prescriptive.
Excellent. Thank you, Sarah. I don't think we've had any other questions come through as of yet. However, I have had about 7 or 8 people asking for a copy of the slides. So I will endeavour to get those over to you, along with any CPD certificates that you have requested. It'll probably be later tonight or tomorrow morning, if that's okay for everyone. Thank you very much to Sarah for delivery today, despite our mild technical hitch. And thank you so much to everyone listening for sticking with us